sitting. Kindly proceed.
Thank you very much, Mr. Deputy Speaker. May I say before I make my few remarks on this very important bill that I was impressed today to see the Honourable Member of Siparia present in the House, because I've been here since, I believe it is the 16th of March, and I have not been accustomed to seeing her in the House. And my concern at not having seen her before was exacerbated today as I saw her being assisted as she left the House, and I'm concerned that she might not be well. I wish her well. Mr. Deputy Speaker, my task this afternoon is made comparatively easy by the very rich pilot of the Minister of Finance who has piloted the amendment to this bill. And the remarks that I will make are really by way of emphasis more than anything else to that which has already been put before this Honourable House by the Minister of Finance and our acting Prime Minister. The first point of emphasis is to emphasize, may it please you, Honourable Deputy Speaker, that this is a very important piece of legislation given the fact that the Bills of Exchange Act dates back to 1884, and what this government is doing is moving this country into the 21st century to deal with modernizing the entire monetary system to enable secure transactions and expeditious transactions in the check-in system. And I'm proud to be associated with that initiative of this government to modernize our system. The undoubted benefits of moving to electronic check clearing to eradicate delays and to ensure a secure check-in system are without dispute, and I entirely endorse the move of this government to bring that to this House. Significantly as well, Honourable Deputy Speaker, I emphasize the point that has already been made by speakers on this side before me, that this has been a collaboration by this government with the Central Bank and the Bankers Association, and I commend that very august institution, the Central Bank and the Bankers Association, for working with this government to bring this very innovative and secure piece of legislation to this House. May I also emphasize a point that has already been touched on by previous speakers, and that is to say that the innovations that are being introduced by this amendment to the Bills of Exchange will not affect or impact on the normal average customer who is presenting his checks or her checks in the normal course of transacting business, and it is really designed for banker-to-banker clearing facilities and secure exchange of checking facilities in the financial system. And that point is emphasized because everybody would appreciate that we are not all, as lay people, as familiar as we would wish we were with the electronic uploading of checks, and there are also risks involved in allowing that to be done at the customer level. And therefore, I think that that is not yet a step that this country is ready for, and we are happy to endorse the clearing at the level of bank to bank. And I endorse that and support that 100%. The efforts of this government with the Central Bank and the Bankers Association go back to a project that has been in train for as much as 5 years, since 2019. And again, it is largely modeled, as we have been told, on the United Kingdom Small Business Enterprise and Employment Act 2015, which implemented electronic check clearing in the United Kingdom. But, Mr. Deputy Speaker, it is very significant in the advancement that is being made by the amendments to the Bills of Exchange Act that we are now including a defined and definitive rule for the Minister of Finance and the Central Bank of Trinidad and Tobago. An example of the modernization of the legislation tells us that nowhere in the existing legislation prior to this amendment, quite remarkably, is there any reference to the central bank's rule or the financial Minister of Finance's rule. And I commend once again the fact that this government is bringing us into the 21st century to enable this facility to be permitted under this amendment. The presentment of a check by electronic means. And I emphasize the point that it enables the provision of electronic check clearing in Trinidad and Tobago as between banks. May I take the opportunity as well, Mr. Deputy Speaker, to emphasize the point that has been made already, and that is the point that the presentment of checks by electronic clearing by the enactment of Section 89A10, as provided for in Clause 5 of the bill, maintains for the purpose of evidence before the court that the electronic image of the check is admissible in evidence as if it were the physical check. That needs to be emphasized because as a former practitioner before the courts, I know the difficulties that are existent in the admissibility of paper documents, the storage of paper documents over years, and the rehabilitation of those documents when one comes to present evidence before the court. The fact that we will now be allowed to present the evidence of checks by way of an electronic image is going to contribute quite significantly to not only the justice that will prevail within the courts, but the speeding up of the justice system so as to enable this government to go against the fraudsters who are perpetrating frauds on the country and the people of this country on a regular basis, and to bring those people to the rule of law and to book. Mr. Deputy Speaker, I emphasize the fact, and this is a point that was touched on a minute ago, I emphasize the fact that the amendment to the legislation is going to allow the central bank to make regulations once this amendment is brought into law. And the importance of the oversight of the Central Bank of Trinidad and Tobago cannot be underestimated. The Central Bank of Trinidad and Tobago is a very august, very able and credible institution upon which our entire monetary system reposes. And it is without any question necessary that that institution be given power to pass regulations. And indeed, if I may touch on one of the points that was made by the leader of the opposition a moment ago, just to answer that, there can be no question of the efficacy or wisdom of guidelines being passed by the central bank to help to do that which it is empowered to do and has done so well over the years of the independence of this republic. And that is to say, to provide guideline oversight on the stability of our monetary system. And to suggest that without recourse to Parliament, the guidelines to be brought into effect by the central bank, if permitted by the legislation that we are about to pass, is somehow or the other a retrograde step, is really defeating the seriousness of the conversation that we are engaged in to have here today, including the fact that somehow or the other there is some difference in principle between ensuring affirmative as opposed to negative resolutions. Whichever resolution is provided for in the amended regulations and in the amended legislation will have the oversight of Parliament. It is simply a difference in process, and at the end of the day, fundamentally still subject to the oversight of Parliament. What the negative resolution does is to contribute to the speed which financial systems need to operate with, so that a regulation or an order, in this case an order provided for by the Minister of Finance, prescribed to be subject to negative resolution, means that if when that goes before Parliament, someone under the order paper is of the view that it should be debated, will call for that to happen. The resolution, the guidelines and the regulations will still therefore be subject to parliamentary scrutiny. So it is really not much to the point to suggest that there is something significantly different and retrograde between the facility of a negative resolution compared with an affirmative resolution. Mr. Deputy Speaker, I am not going to belabor the point much. Much has been said by the speakers who have preceded me, in particular the Minister of Finance, Acting Prime Minister, and the Minister in the Ministry of Finance, so that I am not going to, as I say, belabor the point other than to stress the importance of these debates on this piece of legislation to ensure that we bring expeditious, secure check clearance to the monetary system of Trinidad and Tobago so that we can move forward in the shortest possible time to ensure that we bring sanity to our check clearance system in an expeditious way. Permit me to make one final remark, Mr. Deputy Speaker, on a comment that was left with us by the Leader of the Opposition as she was assisted out of the House. And that was to cast an aspersion on the comments that have been reported to have been made in the Privy Council in a recent matter which has been engaging the Privy Council, and to somehow suggest that the remarks that were there made are to be attributed to this government. Let me go on record to say that this government has every confidence and trust in the judiciary of Trinidad and Tobago. And let me put it on record that within 24 hours of having learned that the remarks had been made, I dispatched a letter to the instructing attorneys in London to record the fact that this government has every confidence in the judiciary of Trinidad and Tobago. I was assured by the instructing attorneys, Charles Speechlys Russell, that the remarks were misquoted in the media, and in any event, the lead counsel for the government of Trinidad and Tobago in that appeal clarified his statements to the Privy Council the following day to make it quite clear that he had not said and should not be misquoted to suggest that there is any lack of trust by the Parliament or the government of the Republic of Trinidad and Tobago in the judiciary, and I would like this House to record that confidence. I don't wish to trouble this House very much further, Mr. Deputy Speaker, with any further remarks. I would beg to move that I give every support and that this bill be passed in the House at the earliest opportunity. Thank you very much.
I recognize the member for Couva South. You have 30 minutes.